Um, did you read the email from the federal court?
I do. The last email I read was about the listing of the matter at the end of the month and the directions hearing. Has there been a subsequent one?
No. It's the listing of the matters. So basically, they transferred the matter to the National Registry after the complaints that I made.
Yeah.
And therefore, there's a Queensland judge that's.
She, and I'm thankful for the work you did.
Your voice is.
Sorry, is that better?
Yeah.
Yeah, no, I had a quick look at her bio, the Queensland judge.
Yeah, so the day before she was given the matters, I received a response to my email from the week before, saying that the matters had been transferred to the national allocation thing, and basically they would get back to us as soon as the matter was allocated. And then I'd also requested for an urgent hearing in the injunction matter, and they basically asked me to file the documents along with an urgent hearing application to make the application. So I've gone through the profile of the judge. She seems okay. She's actually published an article about injunctions and declaratory relief. So she's been involved in a fairly high-profile injunction proceeding, which had declaratory relief as one of the things sought. This was a case of Redbubble versus forget who, but it fairly publicized case, and was a Court of Appeal matter. And I think she was I'm not sure whether she's a Court of Appeal judge regularly, or whether she was just sitting in that matter, but she was one of the people involved in the matter, and then she's written an article about declaratory relief and injunctions and so on. So she knows about the subject.
That's good.
Yeah, not as much as I would by now, but definitely enough to know what Gorton did was basically atrocious. So that's the first thing. The second thing is that she used to write for a magazine in Queensland for I think almost 1.5 decades. And her articles were about a range of things, but essentially about helping people in drafting better affidavits and so on and so forth. So she was a regular columnist in QLS Proctor, which is, I think, their law society website in Queensland. And she's been a barrister for over 2 decades before she...
Yeah, I saw that.
And her father was a judge of the federal court as well. So, she's currently the head of the Australian New Zealand Committee on basically it's a body that decides or that harmonizes the court rules across the state jurisdictions, the federal jurisdiction, and New Zealand. And she represents the federal court, and she's also the chairperson right now. of that committee. So from Victoria, it's actually the Chief Justice who's the representative. So it's Niall. And generally, the judges in that committee are sensible. It's not mindless responsibility, because they basically have to decide what rules should be appropriate for the conduct of proceedings and so on. So, so she has, some responsibility, and I think she's going to be okay, so long as we, so long as we do the thing properly. I mean, one thing that's clear is that, the court has accepted our complaint about the LSB's interference in through the local registry.
Yes.
So I think that's going to be helpful. We should raise that matter in the Supreme Court as well. I mean, I will, but the one thing is that the incoming judge would also be aware of it, why she's being given the matter, and it's it's not going to be like we're making allegations without any proper basis, sort of thing that the LSB has up until now tried to pretend. Okay, so did you have any questions about what I just discussed?
No. That's all good. As I said, I had looked at a bio and I thought it sounded reasonable too. So that sounded good to me. The only thing, of course, was that the matter was not listed until the end of the month.
Yeah. So basically, she has asked for. She has asked for how we, our what has she called it? Basically, she's asked for submissions about how the matter should proceed, the bankruptcy matter, by tomorrow midday, and she's listed the substantive matter at the end of the month, or early next month, depending on the availability thing. But what I want to do tomorrow is basically lodge the documents that I've been working on for the Gorton matter, and raise a bunch of constitutional questions in the bankruptcy matter, and with the other matter, we basically say that it needs to be heard urgently because they're preventing the it's basically obstructing the hearing of other matters or our ability to conduct other matters. And so what these assholes did with the Olney matter is that I told you the previous day the VGSO wrote to us and said that they were willing to have the matter extended until the next thing. So first I was trying to complete the transcripts, but when they couldn't be completed, I was going to write to them and say that we were going to consent without accepting the legitimacy for their reasons for extension. But right after the federal court listed the matter, the LSB, within 5 minutes of that, they wrote to us and they said they no longer seek an extension. And then they basically filed a summary dismissal application of their own. And now the matter is listed on the 17th, which is ridiculous. Like, we didn't get to file the things, and they filed it at the last minute. And so I'm going to have to write tomorrow to the court and I mean, for one, there's a clash of dates because the federal court matter is also listed on the 17th. So I'm gonna ask for that. But the other thing we need to do is basically say that the we're gonna file the affidavit of lawyer A and all of that in the Supreme Court matter, which we won't be able to serve because of the orders of the court, and then we'll go to the federal court. So basically, I've progressed the case against Gorton quite substantially. Much of it basically goes on the transcripts.
Yes.
I mean, even the appeal basically will be on the transcripts. So after the transcripts are finalized, I think the appeal document, we'll keep it fairly slim, and we'll introduce the transcripts through an affidavit. So we'll exhibit them to the affidavit, and the appeal document will basically just refer to the line numbers of the thing rather than copy pasting the content again. So it's going to be fairly lean, and it comes out very strongly, so I'm not concerned about I'm not nervous about the appeal at all. He's
that's good.
completely fucked. So long as they see the thing, there's no way they can uphold the stupid thing that he's done. The trick now is to get all the material before them immediately, and so there's two different things that need to be summarized. There's the transcript and evidence material, but then there's also the authorities around declaratory judgment and some of the things that he's done wrong. The one area which is a little bit complicated that I'll have to explain in detail is the declaratory judgment part, because basically there's some confusion that even good judges have about where declaratory relief is appropriate and where it's not. And I've now gone through everything and I understand what the basic principle is, and it's that whether there's I discussed this previously, that whether there's everything that the court should have access to in order to finally determine the issues between those parties. So, whether everybody whose interests are being affected is there, whether there's any concern about, any unforeseeable, not unforeseeable so much, but whether any relevant aspects of the controversies between the parties is not covered within the, circumference of the issues before the court at the time. So what the court doesn't want is, so for example, if one party says that if it is let's say if it is a commonly agreed fact that one party has ownership of a building, and the dispute arises about whether or not something that one of the parties has done, or something to which one of the parties was to be entitled, whether that creates an interference to the ownership of the first party, then in a case where the interference does not actually affect the ownership by the first party, the court will not make a declaration that the ownership of the first party is established, because just because the two parties were assuming that the first party had ownership does not conclusively mean that it had ownership, because some other parties may have had some claims or so on and so forth. Do you understand?
Yeah, I do.
So what I'm saying is, it's in cases of that sort where the matters before the court cannot theoretically conclusively determine the nature of rights and obligations. But our cases are not like that, because what we're saying is that there is a duty that has been violated, and the matter from start to finish can be, conclusively captured by the facts before the court. So there is no unknown before the court. Like, for instance, it would be an issue if, let's say, okay, so I can see a couple of things that I had asked for that could be appropriately rejected. Like, for instance, I had sought declarations effectively about the fact that the LSP should not be allowed to investigate me. Now, it was in relation to the specific investigations they had on at the time, but because I could not conclusively define all the investigations they had, because I did not have that information, the court.
Yeah, no, I'm understanding exactly what you're saying. I mean, it's clearly just a situation. The court should determine it if they can do so conclusively.
Exactly. And in that case, they couldn't, because they couldn't conclusively say that no investigation against me about unqualified legal practice could be instituted, because it would be too hypothetical. Because the number of cases, like the number of circumstances that it would have to consider to rule every possible scenario out would be too vast. So if I could, what declarations are good for are, particularized facts where you can, say in a pinpointed.
Surely, like, wouldn't be a particularized fact that, say, the appointments of Nailon and Cooper were, invalid.
Yeah, no, that's straight away.
That's what I'm saying. Yeah.
And even the renewal of licenses, that's straightforward fact, because it's not so much that you have to prove that you've not done anything wrong. It's that they have to prove that they had a cause of action. So you're not basically asking the court to affirm that you've not done anything wrong. It's that you're saying that based on what they've presented so far, there's no basis that arises, and so on and so forth. And also, they could not have kept anything that was relevant away. So, basically what he's said is stupid. And also it's counterintuitive, some of the things that he's doing, because what he has, on one hand, he said that don't know if you read his judgment, but basically he has ruled that it is arguable that we were effectively defamed if we hadn't done anything wrong. So what he has ruled is that the way the LSP matter was publicized in the media, and the way the whole thing was it's been talked about in the public domain, arguably gives the impression that we are corrupt and dishonest and incompetent, He's actually helped us out quite a bit. He's basically made the findings for defamation. So he's given you a cause of action for defamation along with me, and said that it's arguable that even for Lulu, it would hold. So he has said that because of the publicization and the way in which it's being discussed in the public, there's an arguable cause of action that our reputations have been ruined, and if we were to get declarations about the impropriety of the appointment of those people, then we would benefit from the vindication of our So basically he's conceded that if the court later on rules that we have done the right thing, then, or we didn't do the wrong thing, then our rights would be vindicated, and people would accept that we didn't do the wrong thing. Now the problem with his approach then is that, so he said that's a proper basis upon which the matter should proceed, and therefore we should get the appointment set aside. But then he says that he doesn't see any utility in getting orders of improper actions by those people, because he doesn't see how that could help. Now the problem with that contradictory position is that even for the first position, the claim about improper appointment, if after appointment what they did was illegal, then that is evidence of, or that can be evidence rather, of the improper motive underpinning their appointment.
Well, wouldn't it be, sorry to interrupt, wouldn't the argument be that if the appointments are found to be improper, then everything they've done is illegal?
Yeah, so, okay, but now you're reinforcing what he's saying. So what he's saying is, why do you want to specifically get determinations about the malice with which they try to take actions? Because if it is basically what you said, so then it makes it redundant whether or not after appointment what they did was particularly malicious. Because if the appointments were wrong, then everything is wrong in the first place, and none of that remains. So that's what he has said, basically, that you don't need to inquire into their motives, the motives with which they took individual actions, because ultimately, if they were appointed for an improper purpose, or if their appointments were unlawful, then none of that matters. But
aren't we saying, sorry to interrupt again, but aren't we then saying, okay, we're saying, okay, they're appointed incorrectly, then everything they've done is illegal. However, what we're saying is that we can conclusively show that that's the case. So you should determine it.
No, so we won't be. The argument that I'm making is not a direct argument. It's the argument of inferences that can be drawn. It's the argument of consciousness of guilt or post-offense conduct. So, based on how people behave after the occurrence of an event, you can draw inferences about their motivations before the occurrence of the event. So, for instance, let's say if there's a crowd of people and they basically collide with one person, and the person falls after being stabbed, and one person is running away from the victim and everybody else is going to check on him, you would presume that the guy who stabbed him was the guy who was running away from him. You know, like if 9 people were in the vicinity of the guy, and one person runs away after he was stabbed, and 8 are checking on him. So in that case, it's not that he was running away that is the proof of the fact that he stabbed him. It's an inference that you draw. So about these people, the fact that Rapke invited the Channel 9 people in is not proof of the fact that his appointment was unlawful.
No, I
but
agree with that.
you can draw inferences from that if he wanted to do his job properly, then he wouldn't have done what he was doing. So if there are other things that could show that he was appointed for an improper purpose, then this strengthens it. And where there's some doubt about the legality of the appointment or the motivation with which it was being. So let's say if you have a situation where the court doesn't have enough to determine conclusively whether they were simply making a mistake in the appointment or whether they deliberately wanted to harm me, then we can say that what they did after the appointment gives evidence about what their intention was before the appointment. So that's where it's important. But otherwise...
I follow what you're saying.
Yeah, so in that sense, his argument is stupid because it's a well-accepted fact that after the event, whatever happens is relevant to explain what the motivations were before that. And then the other issue with his reasoning is that by his own account, him making all those adverse decisions against us in circumstances where they can later be undone, strengthens the grievance that we have about the reputation being harmed and so on and so forth. Do you understand?
I follow what you're saying.
Because all the stuff that he's said and done further reinforces everything that has been happening. So it's not that he's unaware of the serious consequences of his actions, but doesn't give a shit sort of thing. So those are new things that I picked up from his judgment. So it's basically a hot mess, his judgment. There's no...
It's basically a what?
Hot mess. Like...
Right, okay.
It's all over the place. There's no coherent reasoning. And he's basically, desperately tried to stitch things together. And it's very haphazardly done. And... like he's during the hearing he was telling Lulu that he thinks it's unfair that we're seeking tort law relief.
Yes.
And clearly he was basically he wasn't complaining at that point about the sufficiency of evidence or the procedural fairness to the parties against whom the declarations were being sought. And Lulu had also made the point that it's not like, we're ambushing anybody or they don't have an opportunity to address the matter. But in his judgment, he basically sought to rely on authorities that, argue that where the grounds are not properly made clear to the parties against whom the declarations are sought, then they can be prejudicial and so on and so forth. So, it's basically dishonestly done. He's clarified his intention during the hearings, and then he's tried to obscure the matter and then rely on very specific authorities that don't actually support his case, but argue that in other cases, declarations may not be appropriate for the same remedy that we're seeking. So, basically, we need to bring it out in front of the federal court as well to get them to, reopen the matter in the interim. So, we need to do an affidavit today, like your affidavit, to exhibit the transcript excerpts and basically a letter to Gorton.
That was your document you're talking about?
Yeah. So I'm not sure whether I'm going to do it in one document or split it, but at the moment I've split it between the trial hearings and the pre-trial hearings. So the trial hearings being the 20th or the 1st of August to the 1st of October, and then everything before that being pre-trial hearings. I'm not sure whether I will ultimately merge it, but I think there's some utility in keeping it that way because it makes it handy for for the court to refer to things. Like they don't have to have the whole thing when they're just looking at the trial hearings and so on. So anyway, those two documents, and then like a letter in which I clarify the things that he's done wrong with the evidence and the authorities. So everything that was not covered within the transcripts, I'll write to him, and then we exhibit that to your affidavit. But we should do the affidavit now, and we'll lodge the affidavit in the exhibits tomorrow. But we should do the affidavit today just to get it out of the way, because we need to lodge it in the morning. And
we have to get it sworn too.
Yeah, that's the thing, and it needs to be lodged before 12 in the federal court, and then I also want to lodge it in the Supreme Court. I mean, we'll do one, and I'll exhibit it to multiple things. So yeah, that needs to be done, and then do you have any? The court will be closed today as well.
Yeah. I realise we're going to go after work tomorrow.
Okay, so by the way, do you have to show the registry the exhibits?
When I've done it at the magistrate's court, I've not had to show the exhibits. They've sort of accepted that they've signed it as it is.
So you don't have to take the physical exhibits with you?
No, because what we've basically said with the others that we've done is that they're all electronic. So therefore.
Okay, so then it doesn't make a difference so long as you can do it in the morning. I mean, from my end, I will send you the thing overnight. That's
right, because I'm going to have to get it printed, which is fine. I mean, obviously, it just means I've got to go, have to go to office work or something. So, So when you send it to me, I'll just do it as soon as office work opens.
Okay, so what's the So what's the earliest? What's your schedule like tomorrow morning?
I don't know the schedule. I spoke to the boss earlier and said, you've got a busy day tomorrow, but I didn't really ask what the times were. So
Well, I mean, you'll be able to swear the affidavit in the morning, though, right?
Oh, there'll surely be a time I can do it. Yeah, I mean,
I mean,
I can't guarantee, but I'm sure that there's always a gap between what I do and this. When I say that, there's 90% of the time there's always a gap.
When will they tell you?
I'll know tonight, around about 7:30, 8 o'clock.
Okay, let me know.
Yeah, I'll let you know what.
I haven't slept in a while, which is why I'm struggling with talking as well.
Sure.
So I'm not sure. I may have to rest in a few hours.
No, that's fine. I'll let you know as soon as I know what. What I'll do is I'll tell you when I can do it. That's the easiest. So, in between whatever time, and before 12.
Okay, so my plan is this. I'm getting I'm lodging a lot of documents tomorrow with the federal court about the Supreme Court proceedings, and basically we will also circulate these documents to everybody, through the publications. This is going to be really damning stuff against Gorton. There is a lot of work that's been done over the last week and over the weekend as well. I need you to help with finalizing some of the transcripts and
I'm doing that as we speak.